All right, so let's start with the big story that we are tracking on WION at this hour. The US Supreme Court is hearing arguments in a crucial legal case to determine whether Donald Trump can be on the ballot in the presidential election race. Last year, Colorado's top court had said that the former American president was not eligible because he had engaged in an insurrection in the US Capitol riot. Now, Trump has argued that Section 3 does not apply to him. The presidency isn't mentioned in the clause, and he contends that it does not cover the president and his actions. But also it only applies to people who swore an oath under a covered office. Now, the Supreme Court is hearing oral arguments over whether former President Donald Trump is ineligible to be the president again and can be kept off the ballot altogether. Now, Trump's attorney contends that Trump is the only president since George Washington who didn't hold a prior government office. So the clause cannot apply to him because it can't apply to people who have only been a president.
Someone out of the office of the presidency is impeachment. And so I think if you interpreted Section 3 in light of other provisions in the Constitution like impeachment, while they hold office, impeachment's the only way to validate that they don't have the ability to hold that office and should be removed.
Mr. Murray, can I just ask you about something Justice Kagan brought up earlier, which is the concern about uniformity and the lack thereof if states are permitted to enforce Section 3 in presidential elections. And I guess I didn't really understand your argument or your response to her about that.
Well, certainly if Congress is concerned about uniformity, they can provide for legislation and they can preempt state legislation.
Yes, but you say that's not necessary. But
it's not necessary. In the absence of federal enforcement legislation, these questions come up to this court in the same way that other federal questions come up to this court, which is that a state adjudicates them. If the state hasn't provided sufficient process to comport with due process, a notice, and opportunity to be heard, one can make those challenges. But assuming, as here, we have a full evidentiary record, an opportunity to present evidence.
No, I understand that we could resolve it so that we have a uniform ultimate ruling on it. I guess my question is why the framers would have designed a system that could result in interim disuniformity in this way, where we have elections pending and different states suddenly saying you're eligible, you're not, on the basis of this kind of thing.
Well, what they were concerned most about was ensuring that insurrectionists and rebels don't hold office. And so once one understands the sort of imperative that they had to ensure that oathbreakers wouldn't take office, it would be a little bit odd to say that states can't enforce it, that only the federal government can enforce it, and that Congress can essentially rip the heart out of Section 3 by a simple majority just by failing to pass enforcement legislation. Federalism creates redundancy, and here, the fact that states have the ability to enforce it as well, absent federal preemption, provides an additional layer of safeguards around what really Section 3
Yeah, and I'll ask you about the history when I get a chance again. Thank you.
Thank you, Counsel. Justice Thomas? Justice Alito?
Suppose there's a country that proclaims again and again and again that the United States is its biggest enemy, and suppose that the President of the United States, for diplomatic reasons, think that it's in the best interests of the United States to provide funds or release funds so that they can be used by that country. Could a state determine that that person has given aid and comfort to the enemy and therefore keep that person off the ballot?
No, Your Honor. This court has never interpreted the aid and comfort language, which also is present in the treason clause. But commentators have suggested, it's been rarely applied because treason prosecutions are so rare, but commentators have suggested that, first of all, that aid and comfort really only applies in the context of a declared war, or at least an adversarial relationship where there is, in fact, a war between two countries. And second, the intent standard would do a lot of work there, because under Section 3, whatever the underlying conduct is, engaging in insurrection or aid and comfort has to be done with the intent to further the unlawful purpose of the insurrection or to aid the enemies in their pursuit of war against the United States.
Now, let me come back to the question of what we would do if different states had adjudicated the question of whether former President Trump is an insurrectionist using a different record, different rulings on the admissibility of evidence, perhaps different standards of proof, then what would we do?
Ultimately, this court would, first of all, if there were deficiencies in the record, the court could either refuse to hear the case or it could decide on the basis of deficiencies of the record.
Well, would we have to decide what is the appropriate rule of evidence that should be applied in this case? Would we have to decide what is the appropriate standard of proof?
All right, so those are some of the arguments that are being heard at this moment in the court. And to break down what in fact is happening and why this case is so important for the big presidential elections in the United States of America, we're being joined in by my colleague Susan Tehrani, who's joining us live from New York. Susan, this is such a crucial landmark case that is at this moment being heard. Tell us what this case is all about and what are the likely ramifications of this case for Donald Trump's campaign to become the President of the United States again.
So it's regarding Donald Trump and Colorado, as we have been hearing from Trump's attorneys and the state's attorneys, whether or not a state can bar a presidential candidate from not appearing on a ballot. And the reason it's so detrimental is this is the case at the Supreme Court that will determine whether or not Donald Trump will eventually be on the primary ballot for the Republicans and take part in the general election, because whatever ruling the Supreme Court gives on this case, then other states will have to follow as well. We're expecting something to come out, a ruling to come out from the Supreme Court as early as March 5th. Remember, March 5th is Super Tuesday. It's when Colorado and more than a dozen other states go to their primary elections and try to, in order to elect their desired Republican candidate, the GOP candidate. It's the GOP primary. So it's very important in that sense. It also really brings into question not only the authority the federal government has, but the state government as well, not to mention, the courts and Congress, who ultimately gets to make decisions regarding cases like this. And you can see, we can hear it goes, the discussions and the arguments are going as far back as the time of George Washington and Thomas Jefferson, hundreds of years ago.
Absolutely indeed. And what at this moment, Susan, is Donald Trump's defense against this case that has been brought against him to make him ineligible to be on the ballot?
So we're going to hear from Donald Trump shortly. Actually, 11:30 local time was the time that he wanted to comment on this case. But basically, their argument is that Section 3 of the 14th Amendment does say that insurrectionists cannot run for office, but it doesn't mention the President of the United States. It mentions individuals in other categories of office. And so that's their argument. But then the state is arguing that insurrection is insurrection. Another argument that the president's team is putting forth is that Donald Trump was not involved in an insurrection. That's something that the judges can rule on as well. And then ultimately the authority, basically, whether the state has or not to bar a candidate from running for office. That's something else that Trump's lawyers are arguing, and that's something that will be determined.
All right. All right. Thank you very much indeed, Susan Tehrani, for joining us and getting us all those details there. WION is now available in your country. Download the app now and get all the news on the move.